This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about corporate owners are not acting or existing as innocent co-insureds when one corporate owner commits arson in an attempt to profit from his insurance company, and why arson by the insured's management voids coverage. It just doesn't pay to set fire to your own property. Arson for profit is a cause to void any insurance policy that insures against the peril of fire. Following a fire that destroyed the Press Bar and Parlor in St. Cloud, Minnesota, the insurer denied coverage after its determination that Andrew Welsh, a controlling officer of the insured, intentionally set the fire and submitted a false proof of loss. The insureds filed suit. The district court concluded Andrew's conduct barred recovery under the policy and granted summary judgment to the insurer. The corporate entities appealed, claiming to be innocent co-insureds. In a case entitled Timeless Bar Doing Business as the Press Bar and Parlor et al. Versus Illinois Casualty Company, the United States Court of Appeal for the Eighth Circuit on July 22, 2025, resolved the claims. In 2016, Andrew and Jessie Welsh, then husband and wife, purchased the Press Bar and Parlor. They managed the business through two legal entities, Horseshoe Club, LLC, which owned the real estate, and Timeless Bar, Inc., which operated the bar. Andrew and Jessie were the sole members of the LLC and the only shareholders and officers of the corporation. Illinois Casualty Company issued a business owner's policy that provided coverage for the bar's business property and operations. Timeless Bar was the named insured under the policy, while Horseshoe Club was an additional insured, and neither Andrew nor Jessie was named an insured nor an additional insured. The Press Bar and Parlor in St. Cloud, Minnesota, was destroyed by fire on February 17, 2020. Timeless Bar and Horseshoe Club submitted a claim to ICC stating the fire was of unknown origin. Law enforcement found that Andrew Welsh, a controlling officer of the named insureds, intentionally set the fire. ICC, the insurer, denied the claim based on three policy provisions: concealment, misrepresentation or fraud, dishonesty exclusion, and intentional acts exclusion. The district court concluded Andrew's conduct barred recovery under the policy and granted summary judgment to the insurer. Timeless Bar, Horseshoe Club, and Jessie Welsh appealed the decision. Jessie Welsh's claims were dismissed due to lack of standing as a non-insured. Andrew's conduct was deemed attributable to both business entities. The court held that Minnesota's statutory protection for innocent co-insureds did not extend to corporate entities. The court affirmed the district court's judgment denying coverage for the loss or damage caused by the fire. Coverage under the policy was subject to a number of conditions. One of the listed conditions was categorized as concealment, misrepresentation, or fraud with respect to loss or damage caused by fire. The policy, as relevant to Minnesota insureds, refused to allow coverage for any fire intentionally caused by the insured. Because neither of the corporate entities nor Jessie were involved in setting the fire, they contended the policy must be reformed to permit recovery under Minnesota's standard fire insurance policy. In relevant part, the statute provides that a policy is void only if the insured has willfully and with intent to defraud concealed or misrepresented any material fact or circumstance. Jessie and the entities assert that ICC's denial of coverage violates the standard and Minnesota case law. Accordingly, the arsonist's conduct was attributable, however, to both corporate entities. To extend the innocent insured doctrine as urged by the entities would insulate businesses from the misconduct of those authorized to act on their behalf, something that does not find support in Minnesota law or in its case law or anywhere else. As noted by the district court, the policy determination of whether coverage should be extended to innocent, non-named business owners rests with the state legislature, not with the federal courts. In my opinion, when a person in control of two corporate entities commits arson for profit, he and the corporations he controlled committed fraud when a proof of loss was submitted saying the fire was accidental. The corporate entities could not be innocent co-insureds when they were controlled by the arsonist. In this case, crime simply did not pay. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 150 blog postings. You can also subscribe to these videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.